I appreciate the time before the board. Good afternoon. What I would like to do is just briefly address some comments to the folks that are calling this a witch hunt and just ask you folks in a polite way, because what I saw this morning was a disgrace for adults to act like that on both sides. I mean, picking at each other and that stuff, and I know I'm doing a little bit right now, but we should come together and find solutions rather than being divisive. And so this back and forth, and the girl, like, what, in our mid-50s? I mean, I am early 50s, so it's just ridiculous to watch this go on. I know that people across the country watch these and drink and have fun at our expense. But you talk about a witch hunt. So to what extent have you folks went and pulled the documents relating to the Zogg Fire? In 2010, the community of San Bruno was blown up by PG&E. They were prosecuted in federal court for it. They're currently on federal probation for it. So I will say this. I don't vote. I'm not political. I'm not left. I'm not right. But everything that Supervisor Cry has said about the Zogg Fire and every question that he's raised is legitimate and valid. And I've done a bunch of research. I've reviewed the federal court documents. I've gone to room 219, which is the criminal court clerks here in Shasta County. And I've gone to room 319. There's documents from 319, which is the civil court clerk's window. There are a number of documents that can be pulled through FOIA requests. PG&E admitted in the federal court proceedings that they marked that tree that caused the Zogg Fire. They admitted under oath through their attorneys, specifically Mr. Orsino, O-R-S-I-N-I. So that tree was marked. It's either 6658 or 6657 in one of their studies. So the fact that Ms. Bridget, in her press conference, which I watched the Board of Supervisors meeting with Supervisor Cry, questioning Ms. Bridget. She is conspicuously absent today, which is sort of funny. But in any event, Ms. Bridget lied in the press conference and said that Judge Flynn's 995 ruling prevented the DA's office from bringing the case to criminal trial. That is an absolute falsity. I've been doing criminal trials for 23 years. I've been in the criminal system as a prosecutor and defense lawyer for 25 years. And so there's a penal code section provision that allows the prosecutor to dismiss and refile or refile charges after a case has been dismissed. It's penal code section 1387. So when Ms. Bridges said she wasn't happy about this civil settlement and it could not proceed to trial, that is an outright lie. Ms. Bridget did this civil settlement for $50 million, and of that, the poor residents of Igo got $200,000. Ms. Bridget is a board of director as well as an officer of the Children's Legacy, to which she donated $7 million. There are very strict rules about financial transactions with the California State Bar when it comes to self-dealing. That is allocating money from a public settlement, which should have gone to the people of Igo, who are getting screwed by the DA's office, and $200,000 is a pin. So I will simply say that Ms. Bridget helped PG&E get away with murder on the Zogg Fire, because in my mind, as a former prosecutor who's handled homicide cases and a defense lawyer who's handled homicide cases, I will simply tell you that PG&E, given the San Bruno case, the Camp Fire, there was another fire I think called the Daniels Fire, PG&E has been on plenty of notice for years and years and years about what's going to happen if their transmission lines go down. And that if anyone goes and pulls this federal probation case, you will get this judge, Judge Alsup, A-L-S-U-P, who is infuriated by PG&E's conduct, has...
I'm going to allow him to speak. Thank you. Quiet from the floor, please.
All right. Judge Alsup has written a number of opinions and decisions and questioned and grilled PG&E's lawyers at length and ordered them to issue an order to show cause about why they misled the court. So everything that Supervisor Cry has brought up about the Zogg Fire is absolutely valid. And I'm not here to endorse Mr. Cry or toot his political horn. I'm here to show that this district attorney's office has continued a pattern of unethical behavior. Last week in Superior Court, one of our deputies was chided and reminded and scolded by Judge Wood about breaching at least 3 or 4 rules of professional conduct, violating the ethical canons. Nothing has changed since last year's election. In fact, the fact that she got 2 more years, I think the legislature, not you guys, I think has only emboldened her. And this civil settlement is really, she's stolen and swindled the people of Igo. She's financially raped them. $200,000 out of $50 million goes to Igo. That's it. When 4 people lost their life, it's disgusting. And for her to sit up here or issue a press conference saying, well, you know, that was Judge Flynn. Judge Flynn issued 995 and we're prevented from filing a criminal case is a complete, well, I don't want to curse in front of you guys. But I will tell you this, that having done a number of homicide cases, and apparently that's what I'm good at, murder charges should have been filed against PG&E. And I will further tell you this, that I've gone back and I've reviewed the preliminary hearing transcripts, at least experts of that hearing. I was aware and around when that preliminary hearing was going on. The criminal defense committee was stunned that the senior prosecuting attorney in that case blundered and blew a critical piece of evidence, simply, and what that piece of evidence is notice, right, and knowledge. And the one piece of evidence that that DA's office did not get into evidence was the fact that PG&E had marked and had studies done and then had delisted. So in other words, that tree was marked for removal, the Great Pine, so it's 6657 or 6658 on their study, was marked for removal by some outside forestry companies, and then PG&E delisted it. And I believe they delisted that Great Pine because that was on private property and they couldn't go in and cut it out. But in any event, so PG&E has been on notice for years about that Great Pine. They didn't do anything about it. And by that, so under second-degree murder theory, it's called the natural and probable consequence. So if somebody acts or fails to act with knowledge that that action or inaction could result in death or great bodily injury, they're on the hook for second-degree murder. So if I was the DA, I would have filed murder charges against PG&E. And I've done... All right, well, in any event, I would put my career handling homicides against anybody else in Shasta County, except I think Mike Borges and I are pretty close together in terms of handling homicides. But for a layperson to come in and talk about a homicide case and what is and what is not the law is a joke. So the one issue, the one critical piece of evidence that should have been brought before the court that was admitted to down in federal district court in San Francisco with Judge Alsop was blundered and completely botched by this Shasta County District Attorney's Office by a senior prosecutor. It just begs the question of why. Whether it was just complete idiocy, or maybe the case was thrown. I don't know, but I simply would say any seasoned veteran prosecutor knows how to lay the foundation, or just lawyer, to get a piece of evidence in. And so there was a point in those proceedings where some other person tried to get the court to take judicial notice of this federal file. And what's curious is that the prosecutor objected. But what's in that federal file is all these documents and pleadings where PG&E admits to having marked that tree, the Great Pine that caused the Zogg Fire.
All right, thank you. I think we've got enough. Shon.
Okay.
Thank you.
All right. Thank you.
Supervisor Gorman.
Shon, I have a question for you.
Yes.
You were mentioning about the dollars for IGO, how they should have gotten more than $200,000. Wouldn't it have been handled from the civil lawsuit, not the civil prosecution?
Say it again. I'm sorry.
Would the dollars for IGO have come through the civil lawsuit instead of the civil prosecution?
They should have been both. So the legal, we're going to get a little legal technical here. The civil prosecution didn't allege damages, and that's the one thing that prosecution should have done, is allege damages, because there was a lot of trees that were burned, a lot of acreage was burned, and so there was this very subtle nuance of not filing the damages charge, because that would have cost PG&E like billions, because you have to pay for a tree, right? So I don't know what's in your wallet, but to get back to Capital One, but what's the value of an oak tree out there, right? And it would have cost billions and billions of dollars. And so if you look at who should have been allocated that money, it still should have gone to IGO. I get that IGO wasn't specifically named as far as the damages go for having trees burned, but you're talking about, and we'll get into the children's legacy in a second, but you're talking about allocating funds off the back of a community that was destroyed, people's lives were lost, right? And so you've quote, earned this money. You've got the settlement off of these folks over here in this corner of the county, and they get screwed and see what, 0.0001% of that settlement? And that doesn't make any sense.
So do you think the civil lawsuit was handled poorly?
100%.
And that was this previous board that approved that?
I don't know, but Supervisor Garman, here's the curious thing.
No, it's okay, Shon. I just want to know a little bit of the difference there.
I know, but can I just finish, please? There was a prior civil settlement for $12 million. In that civil settlement, there was a release of all future claims. So it's curious to me from a legal standpoint how this civil thing could have come about, because in that prior civil settlement for $12 million, it's a done deal.
And who handled that civil lawsuit prior? That was our county. It wasn't the DA.
Yeah,
the county council.
It may have been county council. I
just want to make sure the blame's going to the fair place.
No, 100%.
And I agree. I think the funds could have been spent differently, but I don't believe that the DA I think what you have is we've got two issues. I'm hearing you talk about the money for IGO, which is, in my opinion, the civil lawsuit was handled partly by our county council and our outside counsel that we hired. Then you have the other issue that you brought up as the Children's Legacy Center, where that needs to be looked into. I've sent off my letter, and I would definitely support sending off this letter we have in our packet today as well.
Okay.
So thank you.
And I appreciate that. Thank you.
Supervisor Cry.
Are we under board discussion at this point? Or
We're just talking, yep, under discussion, yes.
okay, so one of the things.
I'm not sure if I sit down or stay here.
Well, yeah, you can sit down.
Okay, all right, thank you.
Yeah.
Now, we do have one, I thought you were addressing Mr. Northam. Otherwise, I still have Margaret Hanson for public comment. Would you like to address this, Margaret? Sure. On this item, R1?
So I'm still having a struggle with it. You know, there's a lot of people that don't want to question the DA about her decisions, but I'm going to question the DA about her decisions because I honestly believe that it was mishandled. It smacks of, you know, there's something going on. And I hate to say that because $7 million for a Children's Legacy Center that she is a part of the board, that right there is impropriety. Sorry. It is what it is. It's the truth. And I'm having a hard time with that because I honestly think that IGO should have gotten the bulk of everything. And I don't know where the other millions of dollars went. PG&E skates again for free, pretty much, because $50 million is not a lot of money to them. So I would question it, and I'm going to keep questioning it. And you know, I know there's a lot of people that want to protect the DA, but I'm sorry. There's something wrong, and it just needs to be dealt with. Thank you, guys.
Thank you, Margaret. Would anyone else like to address this on R1 before we bring it back for board consideration? Seeing none, we'll bring it back. And I guess I can start it off. So we have R1 is to approve a letter to the...
In the queue.
Okay, Supervisor Craig.
No, I just want to make sure because I know that you like to go last. So.
Yeah, but I didn't see your name. So, so anyways, we're going to approve a letter, or possibly, if the board so chooses, to approve a letter to send to the state of California to the Attorney General regarding the Zogg Fire case, you know, prosecuted by the Shasta County District Attorney. And I guess my only ask on that is, I've seen the letter, it's in the staff report, but I'm going to make a motion that we approve a letter sent by the chair of this board, which would be me, and move it forward to the state attorney general. And so that's
I'll second that.
And do we have a motion? Is there a second?
I second it.
You second. Okay, I made the motion. Supervisor Christ seconded it. Now under discussion, Supervisor Brickert.
What you say? It's just coming from you, not the entire board.
That is correct.
What, and what's the justification for that? Because
well, if the board approves it, they'll allow me the authority to write the letter. The letter will be very similar to this letter, but I have a few changes. I'm not going to leave it as is if that's what you mean.
well, then I can't vote for something I haven't seen.
Correct. If that's your choice. Supervisor Garman.
Thank you. I would agree with the same thing. I'd want to see the letter. I think we'd all be entitled to that. If you're going to speak on behalf of the board, it needs to be on behalf of the board, and we need to see what's in it. I would hope that all five of us would want to see that.
Supervisor Cry.
Well, a couple things on this topic that's been interesting to me. I brought up in an era of complete transparency, I made a motion this last meeting about having a special outside entity look into this that we would pick, hire, and pay for. So what we have now is we have no less than 6 or 7 attorneys, former judges, who have volunteered bringing things forward. And Mr. Northam, I had told him, I had said, hey, if you want to come in public comment, come in public comment. Many of the others are not because they're volunteering, they're not being paid. But, you know, it's interesting, Mr. Khan gets up and then you actually are being given exactly why you're so wrong and ignorant on the issue, and you walk out when he's explaining it. I mean, I have the court transcripts. I have everything tabbed. Nothing I've said is wrong, and this isn't a witch hunt. What this is this is 100%. I'm trying to get to the bottom of questions that one gentleman in the audience in public comment had. It was about, did we let somebody murder 4 people in our community and walk in lieu of $50 million? That's my question. It has nothing to do with the DA or who prosecuted it. I want to send a very strongly worded letter to the Attorney General with notations, with court transcripts, because what the county had provided, which I get it, whoever on the staff did it, and I didn't have a chance to ask who did that because I was gone last week and it came out and I didn't come yesterday and ask, but that was 2 paragraphs. That's going to end up on a desk and maybe a intern looks at it in a month or a year. We need to send something that is very strongly worded with cites that we can just get answers. I think the community deserves that. And like Mr. Northam had just said when he came up, who is a criminal prosecutor, who has prosecuted countless murder trials or defended individuals. But what we're seeing is you have the San Bruno explosion. They're on probation, and they want to get off of probation. And I think we sold out for $50 million. And I don't just think that, I know that. I know that at this point. So I would absolutely second sending a very strongly worded letter, and I don't blame the fellow supervisors for wanting to see that letter prior. But I would still vote because I have confidence in this chair that he's going to send a very strongly worded letter.
Councilman McCumber.
Thank you, Chair. Pardon me. I understand that at least the proposed idea here would be for a letter that you would send as chair. 2 concerns come up. One, that appears to be, at least based on the description so far, outside the scope of the item as agendized today. And secondly, and this would go for any letter that comes from a supervisor or board, the action of submitting a letter by any individual supervisor is fine. It would be my recommendation that it be clear that it's from that supervisor as opposed to the board. And on the flip of that, if it's a board authorized letter, then of course that could represent that it's the board's direction. So I'd want to make sure it's clear if, Chair Jones, you're inclined to send a letter on your own as a supervisor, that's fine, but you'd want to make sure, in my opinion, that it was representing that it was on behalf of yourself as opposed to the board. And if there's direction to go further beyond that in order to approve a letter that's not on the agenda, my concern was the first one raised.
Okay. We could bring it back, we could bring this back for future discussion, have the full document present, and then we could send it that way. So I'm going to amend my motion that I will bring back at the next meeting a letter to approve to send off to the Attorney General.
I would second that.
Okay. So we have.
I do have, no, that's fine.
That's fine. Okay.
So, yeah.
Council McCumber.
Yeah, so if it's of course, a motion just to put something on the next agenda.
Correct.
That's not obviously been agendized, but it's okay to say we'll put it on the future agenda.
That'll be on the next agenda. It'll be exact same wording. It'll just be a different letter. That's all.
And for the board's consideration, not a recommendation to do or not do, today's item enables the board, if it's so inclined, to entertain amendments or changes to the letter that's proposed here. Sometimes the letter will come before the board and there's not an option to amend because it's just as presented. So again, not a recommendation to do that now or not, but so the board's reminded that it has that option.
If we had a letter ready to read, would that be something that we'd be able to amend that, even just for our motion that we have right now, where if there was a letter, if there was a letter right now that we read, would we be able to vote on that, or do we have to bring that back?
As I understand the item, I could double check it here, but there's a draft included that could be approved as is or could be amended. So
amended meaning it could have every word stricken out,
I suppose theoretically, so long as that's completed during this item and it's clearly articulated that that's what the board wants to do, then you could amend it here now, have the board vote on whether to approve it or not.
Yeah.
Alternatively, Chair Jones is moving to put a different draft forward for a different day on a different agenda.
The letter that I have is several hundred pages long. Would that be?
No, Yeah, I mean, because I've actually submitted to Patrick.
Right.
Some of the stuff. He's,
I mean, it's the CAL FIRE report, it's all the attachments.
those are all the sites.
Right.
Yes.
So, I mean, it's a lot of attachments. Would those all need to be read? Or would it be easier to just bring it back next meeting?
It would, let me make sure I understand the question, Chair. Let me put it this way, if to the extent there's an item that the board would be considering, regardless of its length
You know what,
or lack thereof, then yeah, I would suggest.
let's just do it next week.
Right.
And we can put it in the board packet, and then they can read it, and then if they choose not to get on board
Yeah.
with accountability for murder victims in this county, they can do that, because it's right here, it's going to be big, and it's all truthful. And then we'll see how much time's wasted while they read it.
So I believe my amended motion does state that we'll bring back a different letter at the very next meeting, and then the board can decide. I think it's been seconded. Is that correct, Supervisor Craig?
Yes.
Okay.
Bring it back.
Any other discussion? Seeing none, we'll call for the vote. All those in favor?
Aye.
Those opposed?
Nay.
Passes 3-2. We'll bring this back at the very next meeting.